In 2012, the Legal Aid, Sentencing, and Punishment of Offenders Act slammed the door shut on state-funded legal support for the vast majority of family disputes in England and Wales. The legislation removed public money from standard private family law cases. Spouses navigating divorce, financial applications, or private child arrangements now fund their own legal battles. But narrow corridors survived. Funding remains for domestic abuse, and one illuminated pathway: public law children proceedings. In standard relationship breakdowns, the state expects individuals to pay their own way. This shifted the baseline of access to justice, making the remaining public funding provisions highly significant. Looking at the funding provisions under the current family law framework, you can see a distinct provision specifically for access to public funding, public law children cases. This exception exists because public child law involves the state actively stepping in to remove a child from their parents' care to protect them from significant harm. When the state directs its resources toward permanently fracturing a family unit, it wields an overwhelming legal advantage. To prevent a complete imbalance of power, the funding rules ensure parents have the resources to mount a defense. We are going to map exactly how, when, and to whom this specific public funding applies, tracking it across the chronological timeline of a local authority intervention. For legal practitioners, mastering this funding architecture is a strict requirement when standing between a family and the authority of the state. Local authority interventions follow a chronological roadmap, the public law outline, starting in the pre-proceedings phase. The first funding trigger activates when the local authority sends parents a letter before proceedings, notifying them that court action is imminent. The moment parents receive this letter, they become automatically entitled to legal help. This funding is non-means, non-merits-based, meaning the legal aid agency does not assess the parent's income or probability of winning. Legal help is restricted. It covers initial advice and correspondence, not courtroom representation. This absolute entitlement applies exclusively to parents. Extended family members, like kinship carers, hit a barrier. Their access is discretionary and subject to strict means testing. Even at this early stage, the system creates a bifurcated landscape. Biological parents are shielded by public funds, while alternative rescuers are financially exposed. If pre-proceedings stale, the timeline advances to Stage 1. The local authority issues a Section 31 application using Form C110A. Funding for parents automatically escalates to full legal representation, empowering their lawyers in court, still free from means and merits testing. Under Section 41 of the Children's Act, the child is automatically made a respondent, triggering their own independent legal protection. To ensure independent representation, CAFCASS appoints a children's guardian, who instructs a specialized solicitor. This legal team is fully funded, granting the child their own non-means, non-merits tested legal aid. Once Section 31 proceedings are issued, the state bankrolls the legal representation of parents and the child, ensuring a balanced fight against the local authority. During the interim phase, the court frequently requires more evidence before making a final decision. Under Section 38(6), judges routinely order complex medical, psychiatric, or independent social work assessments. These independent forensic assessments are highly specialized, and they generate massive financial costs. The 2004 Calderdale case established rules for allocating these costs. The precedent dictates that expert assessment costs should be apportioned equally among all parties. Because the mother, father, and child are legally aided, the legal aid agency absorbs 3/4 of the invoice. Public child law funding subsidizes the required forensic evidence, covering the heavy costs of expert assessments in addition to standard legal fees. At the 26-week timetable's end, the court reaches the final disposal stage, determining the child's permanent fate. The court can grant a care order to the local authority or an alternative option like a special guardianship order, an SGO. SGOs are increasingly utilized in public law proceedings to place the child securely with extended family members, effectively terminating the local authority's involvement. While 2023 rules made public funding formally available for SGO proceedings, applying changes the parameters. Unlike absolute protection for parents fighting care orders, SGO legal aid is subject to a strict means and merits test. Guardians must prove financial eligibility. When the threat of a state care order is replaced by a private SGO placement, the absolute financial safety net vanishes, shifting the burden. The complete timeline reveals public law funding as a targeted architectural framework, where the level of support depends entirely on the specific legal trigger. When the state actively seeks to remove a child, the biological parents and the child are granted an unquestioned right to a funded legal defense. However, the moment the proceedings shift toward alternative carers, extended family, or private permanency orders, the strict financial barriers of LASPO immediately reassert themselves. Misunderstanding these boundaries is a critical error. Advising a kinship carer that they will automatically be funded, only to hit a means-testing wall, creates devastating financial obstacles for vulnerable clients attempting to help. Mastering the architecture of public child law funding provides practitioners with the map needed to navigate the narrow corridor between the power of the state and the